More than 2 million federal employees work on behalf of the American people. They care for veterans, enforce the law, ensure the safety and quality of our food and drinking water, conduct scientific research, and repair our warfighting equipment, among many other important tasks on behalf of the American people. They're also represented, in many cases, by unions, because Congress determined by law that giving federal workers the right to join unions and bargain collectively over their conditions of employment was in the public interest. In fact, that law states, and I quote, "The statutory protection of the right of employees to organize, bargain collectively, and participate through labor organizations of their own choosing in decisions which affect them safeguards the public's interests, contributes to the effective conduct of public business, and facilitates and encourages the amicable settlement of disputes between employees and their employers involving conditions of employment." Congress created the Federal Labor Relations Authority to administer, interpret, and enforce the system of labor management relations. The FLRA is part judicial, with a 3-member authority, and part enforcement agency with its Office of General Counsel, and part arbitrator with its Federal Service Impasse Panel. Under the law, the FLRA shall provide leadership in establishing policies and guidance relating to the system of labor management relations that Congress established in law. Today, this subcommittee, the Subcommittee on Government Operations, will examine the Trump administration's leadership of this small but very powerful and influential agency and the consequences of the practices and operations on our system of labor management relations. The Trump administration has made no attempt to disguise its hostility toward collective bargaining, unions, and federal service labor law. But 1 year ago, President Trump issued 3 sweeping executive orders that stripped employees, including whistleblowers, of union representation at grievance proceedings, physically expelled unions from federal offices, and imposed dramatic cuts to the ability of federal employees to represent their co-workers on work time known as official time. A federal judge struck down key provisions of those executive orders, finding that they were, quote, "an improper exercise of the president's statutory authority," and illegally conflicted with the rights, duties, and procedures that Congress had established in law decades earlier. The judge also wrote that many of the challenged provisions of the orders at issue were here effectively reduce the scope of the right to bargain collectively, as Congress has crafted it, or it impairs the ability of agency officials to bargain in good faith, as Congress in law has directed. Much like the president who appointed this chairman, the FLRA chairman has exhibited unprecedented anti-union bias. Chairman Kiko decertified the federal employee union that has represented employees at the FLRA since 1980. No previous chairman in the history of the FLRA under any administration of either political party has ever done that or presumed to do it. This single act reveals, I think, a personal and disqualifying anti-union bias. The explanation for this blatantly anti-union decision is at odds with the Department of Justice's Office of Legal Counsel guidance, which characterized the position taken as unreasonable. As a judge, Chairman Kiko and the other Republican authority members have disregarded long-standing Supreme Court precedents and, in my view, violated the FLRA's own regulations to rule against the unions. Persistent vacancies in the top position in the FLRA's Office of General Counsel have also allowed a backlog of more than 200 documented violations of federal labor law to go unaddressed or unresolved. As a manager, Chairman Kiko has earned a failing grade from the employees of the authority itself. According to the Partnership for Public Services analysis of OPM's Federal Employee Viewpoint Survey, employee engagement during Chairman Kiko's tenure fell 31 points in 1 year, from 2017 to 2018, a drop more precipitous than any other agency measured, and of any small agency. I also have serious concerns about the reliability of representations made to Congress. In a March 2018 letter, Chairman Kiko told Congress that her reorganization of the regional offices of FLRA, which closed offices in Boston and Dallas, would increase the number of agents and have almost no net impact on staffing. In fact, those decisions led to a 21% cut in staff and placed unreasonable burdens on remaining employees. Chairman Kiko's statutory interpretation is, as the Office of Legal Counsel said, unreasonable. It contradicts and disregards long-standing precedent. The anti-union bias seems to be present, if not extreme. The agency she leads has not prosecuted a single violation since 2017. And her mismanagement has demoralized and dismantled the capacity of the principal enforcement agency of federal service law. 40 years ago, Congress codified collective bargaining rights and labor management practices as a critical component of civil service reform to foster an effective, merit-based federal workforce. Congress, and in particular this committee and subcommittee, will continue to value and protect those rights. I look forward to this hearing as an opportunity to put the administration and the FLRA chairman on notice. With that, I yield to the distinguished ranking member, my friend from North Carolina, Mr. Meadows.
Hi everyone, Union Man here, and that intro was a snippet, a clip from the June 4th, 2019 House Oversight and Reform Subcommittee on Government Operations investigating the Federal Labor Relations Authority, and that was the chairman, Chairman Connolly, putting all the actions under this administration in focus so succinctly. So that was great. And so I'm going to go ahead and put that video on the description box. And today we're going to talk about FLRA Use It or Lose It, Federal Labor Relations Authority. All right, so let's first talk about the unions. And the three prominent unions in the federal sector is the American Federation of Government Employees, which is by far the largest, National Treasury Employees Union, NTEU, and National Federation of Federal Employees, NFFE. AFGE has 300,000, by now hopefully, 300,000 active members, and AFGE represents 670,000 employees, which means that 44.6% of the employees under AFGE's umbrellas are dues-paying members. And then we have NTEU with 76,758 dues-paying members as of the latest LM2 report, and NTEU represents 150,000 employees, which means that 51.1% of the employees under NTEU's umbrellas are dues-paying members, and that is a great number. So kudos to you, NTEU. That's great. And then the not so great is the NFFE with 8,642 members out of 100,000 employees they represent. So 8.6% of their employees are dues-paying members. Not great. FLRA, under the Trump administration's appointee running the FLRA, Colleen Kiko, under her leadership, the FLRA has closed 2 offices. One, the second busiest one being after Washington, D.C., is the Dallas office, and the Boston's office was closed since Trump has been in office, and that's a dismantling, a strategic dismantling of employees' rights, because without the FLRA, the agencies would have a freer hand in violating the statute. And so the FLRA doesn't just take care of ULPs. They have other functions as well. They have the FSIP, you know, they do other things as well, but you know, for the purposes of today's presentation, we're just going to focus on the unfair labor practice charges that they investigate and that they hold hearings on. Excuse provided for closure. So this is what their Trump administration's appointees use as the excuse for closing down the 2 regional offices. Regional caseloads operating costs, rental costs, and staffing. And so that was the excuse provided to why they had to pretty much destroy slowly dismantle the FLRA. It's not been that slow though. So the ever disappearing FLRA. So the FLRA's tiny workforce, which has been reduced by more than 55% since the year 2000. From the time Trump took office till June of last year, 2019, in that time frame, because of those two regional offices being disbanded, 21% of the workforce at the FLRA has gone, is left. And this is really a devastating event. The problem is that the unions have done such a poor job explaining what the FLRA is there for. And because of that, employees don't really care. FLRA, and this is another government agency, another alphabet soup agency. What do they do? And that is a foul on all of the federal labor unions, and that's something that really needs to change. The importance, the connection between the FLRA and your rights as an employee has to be explained. That needs to change. So out of 2 million federal employees, in a year time frame, I think this was fiscal year 2019, 4,000 ULPs were filed in a year. 4,000. And that is ridiculously low. And that will be used, mark my words, that will be used by the not-so-friendly politicians as their point to further dismantle the FLRA until one day we may not have an FLRA. So I say file ULPs like it's going out of style. Know that anyone can file a ULP. An employee can file a ULP against the agency, and an employee can file a ULP against the union. The union can file a ULP against the agency, and the agency can file a ULP against the union. It's important that we become knowledgeable and educated and hip to the fact that ULPs are still a thing, and you should be filing as many ULPs strategically. So don't file a ULP on something that may be exigent and that should probably go to arbitration. You should file ULPs on matters that you don't need to resolve super quickly, that you can low risk, that you can sort of kind of afford to hold on till a general counsel gets appointed. Now, there is this misunderstanding with union officials and union representatives and presidents of, number one, what the FLRA is and what they do. And there's this misunderstanding of why you should still continue to file ULPs. So a lot of the union officials I've spoken with say, well, we haven't filed a ULP in years. Well, why not? Well, they don't have a general counsel. Don't drink the Kool-Aid. That is not the right attitude. File the ULP strategically. And we can sure as hell file more than just 1% of the employees, one ULP for 1% of the employees. If just 2% of the workforce filed one ULP per year, and that's against the agencies. If just 2% of the employees, and that's not a lot, that's just 40,000 people out of 2 million, were filing ULPs for violations of 5 U.S.C. 7.1, and there are tons of these violations. The agency's management is engaged in these violations. You can pretty much walk into an office, look around, and say, there's probably 10 of them right now. I mean, if you become really good at understanding the statutory provisions and language, there's tons of violations of the statute. File it. If you've never filed a ULP, pick up the phone and call the nearest regional office and talk to one of the attorneys. They will help you explain how to file ULPs. You can certainly go to FLRA.gov and go through their website and find the contact information for your regional office and speak to one of the agents that will assist you in filing the ULPs. Remember, you're not the expert. They are attorneys. They are the experts in labor law, and they will go ahead and, investigate and flesh out any allegations on these matters. So, yes, the FLRA is still investigating ULPs. They're still preparing them for hearings. And a lot of the ULP charges don't go to a hearing in front of an administrative law judge, for which the FLRA only has 2 ALJs right now. They don't all go to judges. A lot of the ULPs get settled before they go to the judge. So I would say file as many ULPs for low risk violations that could otherwise be resolved through the arbitration process, the grievance process in arbitration. I would say file as many ULPs as you can, learn how to file them. You're going to sometimes face situations where you may file a ULP, and because something wasn't right in how you filed it, they're going to say, yeah, this is not good. Just because they say, yeah, this is not good, it doesn't mean that you just quit. You have to be persistent when it comes to filing ULPs. File the ULP, and then ask them, well, what did I do wrong on this? Well, you really didn't explain it the right way. It would have been better if you explained it like this, and you didn't tick the right box. And just withdraw that ULP. Simple. Withdraw it. Say, yeah, I'm withdrawing it, and then go ahead and refile and do it the proper way. And that's also a way for you to learn how to do it, how to file properly. So don't quit. Keep filing and file. If we were to file just for 2% of the employees in the federal government, we would have 40,000 ULPs, which is currently, that would be 10 times the current filings that they have right now. So please, don't listen to ignorant people telling you that it's not a good idea to file ULPs because the FLRA is being run by a Trump appointee and there's no general counsel. Okay, all true. However, that's beside the point. Yes, there is no general counsel. There hasn't been a general counsel since November of 2017 because the Trump administration has purposely not nominated a general counsel. So in order for the cases to go before an administrative law judge for a hearing, you have to have a general counsel who's going to take the case, look at it, say, yes, this is my stamp of approval, sending it over to the ALJs for adjudication, where a judge will determine whether or not there was a violation of the statute, 5 U.S.C. 7.1. The problem is, of course, that there hasn't been a general counsel since November of 2017. It's very possible that by next year, 2021, we might have a new president who will most certainly appoint a qualified individual as the general counsel for the FLRA. So we're in June now, so we're talking about maybe another 8 months before that realistically could happen. So keep piling it up there. Send as many ULPs as you can to the FLRA, and be patient. If it takes 8 months to get a general counsel in place, then it takes 8 months. If Trump gets reelected, it takes 5 years. It takes 5 years. But remember, the majority of the cases do not go to an administrative law judge. They go and get settled before that. So just be aware of that. So please keep filing those ULPs. File. The general counsel must be nominated by the president and confirmed by the Senate. the Trump administration, for the longest time, refused to appoint a general counsel, and that was done on purpose, of course, because that pretty much, it had its intended impact. It did what it was supposed to do. The Trump administration was not stupid. They knew exactly what they were doing. A lot of people just felt demoralized, and that's the game that was played. Don't be demoralized. Keep filing ULPs. And so he did appoint an individual called, her name's Catherine Byrd, to be the general counsel. Yeah, she was the representative of one of the agencies and was very zealous at implementing the Trump's union busting executive orders. And the union was upset because she was alleged to have violated the statute at 5 U.S.C. 7-1. And so there was a lot of concerns about her experience, and she was confirmed at the subcommittee, as my knowledge. She was confirmed at the subcommittee level, but she hasn't been brought to the full Senate for a full vote. And so that she's not, it doesn't seem like she's gonna, it all depends on Mitch McConnell at this point and what the Senate does. But as far as I know, her nomination was opposed on party line basis. So on the subcommittee, all the Democrats ended up rejecting her nomination, and the Republicans all agreed on her nomination. And so now it's a matter of one vote before we have her as a general counsel, or hopefully by next year, the next president will appoint somebody who would be more qualified to be the general counsel. And all these cases, well, we'll keep those two judges really busy, I guess. But again, the bargaining unit employees need to file as many ULPs. Don't stop filing ULPs because there's no general counsel. That's what they want you to do. And because we've only filed, well, not just the union and the employees, but also the agencies as well, 4,000 ULPs, they're going to ask a question. Why is it that we have one entire agency for only 4,000 ULPs? And they're going to use that as the excuse to continue to dismantle the FLRA. So if we don't use it, we're going to lose it. Anyhows, thank you very much. Please be sure to like and subscribe and visit us at www.unionman.org, and share this video and the rest of the content Union Man produces with your coworkers. And the more people know about their rights, the more people are hip to the situation, the more we can cause momentum to cause the tides to shift the opposite way. Right now, we are under attack, yes, but it's not the end of the world. What we need is clear-headed leadership to guide us in these murky waters and the stormy weather, and this is it. This is the leadership that we need. We need to go forward, file as many ULPs right now, and get them ready. Get that docket filled up. Get those two judges ready to start reviewing those cases, because eventually there's going to have to be a general counsel. There's no way around it. Those who are filing grievances, and you have a good idea that you're going to send the grievance to the arbitration process, if your contract allows it, I know the VA certainly does, the AFGE VA contract, the AFGE, the master agreement between AFGE and the Department of Veterans Affairs, you can put ULP violations within the grievance. And a lot of the grievances are also ULPs. So if you know you're going to take that case to arbitration, start adding those ULPs in there. And there's a benefit. There's a lot of benefit to that. So yeah, you don't necessarily need to have an FLRA administrative law judge to slam the gavel to say that there was unfair labor practice charge. You can have an arbitrator make that same decision, And it has the same weight. Yes, there was an unfair labor practice charge, and the agency needs to do XYZ on top of whatever was in that grievance. And so, thank you very much. Again, like, subscribe, visit us at www.unionman.org, share this with your coworkers, and I hope everyone is empowered to move forward and to, you know what your rights are, act on that knowledge, and collectively we can change things. Thank you and have a great day.